Great. Okay, good morning. Happy Sunday, everyone. As I said earlier, you don't have to turn your cameras on, but I also love to see some of your faces, so like you do you. I talk very quickly. I'm a little bit of a scatterbrain. Those of you who work with me one-on-one, you know this about me. So if you have questions or if I'm talking too fast or something doesn't make sense or you're getting confused, let me know. I will send out the Zoom recording to all of you. So you will get the Zoom recording. You can go back and rewatch this. Hopefully, that's a really helpful tool. I think somebody has a question before we get started. So go ahead and ask your questions if anyone has any questions before we start. Morning, Catherine. Oh, okay. Okay, so this first, I always am worried about I'm gonna say your guys' names wrong. Is it Hale? Perfect. Great. Okay. Okay, so her question is, I need advice slash help with managing time on the MPT. I understand that the solution is probably more practice, but I've done 10 plus and I struggle with the time management. It consistently takes me 2 hours to finish one MPT. I receive a 5 out of 6 and then a 6 out of 6 for my Themis grader on the two MPTs, but both are taking me more than 2 hours. Okay. So one of the problems, right, is that obviously the time. The time is one of the biggest issues students have with the bar or with the MPTs in particular. I feel like in general, the bar exam timing can be really tough for students, but the MPT is really hard, right? And I think one of the issues is if I gave all of you an unlimited amount of time to draft an MPT, you would all get sixes every time, right? You all went to law school, you all took legal writing, you all took legal research, you all have written papers, you've all had jobs, right? You understand how to do it. The problem is the time crunch, right? And so I think one of the best things for timing, in my opinion, is one, having a really clear strategy going into the MPT. And two, having a consistent approach. Okay. Beyond that, I also think that something that is super helpful is doing a lot of them. But for example, if you've done 10 of them and we're still struggling with we're still hitting that 2 hour time limit, then clearly the repetition isn't something that's picking up and we need to figure out a new strategy. So, how many of you would say that your biggest issue with the MPT is time management? Not very many. Some.
Yes, ma'am. That's
Okay.
time management. Yeah.
Okay. So, those of you who do not say time management, what do you feel like? And you can just throw it in the chat. You can unmute yourself, whatever you want. What would you say is your biggest concern with the MPT?
I think sometimes structuring, just because, like, for example, this MPT had a ton of statutes and like two cases and a lot longer, with like other MPTs I've done, it has had less legal basis, but a lot more facts on the file side.
Okay. Okay. Yep, that's helpful. Okay, and the people in the chat are saying organization analysis, organization. Structure, coming up with the arguments. Um,
Ariana,
yeah.
hi, how are you?
Hi, how are you? Good morning.
Good, sweetie. Good morning. One of the things like I am struggling, I received the grade for Barbary,
Yeah.
and they like one of the things like I am like kind of confused because like in 1 hour it is impossible that we put like all the rules, all the status, everything connected with each one of the cases, okay,
Yeah.
that is similar or contrary, like our case.
Mm-hmm.
And they are give like, that is one of the questions. They have like more than an hour. They are
Right.
actually lawyers, okay,
Right.
or people that are training to teach how to do PTs,
Right.
okay, and they are not gonna do it under 1 hour,
Right.
okay, all that they are writing,
Yeah.
okay.
And for
So
context, everyone, Natalia is taking the next gen bar exam. And so I do want to really quickly just pop that in. If you are taking next gen, you have 60 minutes for your PTs. If you are taking the UBE or California, you have 90 minutes. That's why she's saying an hour. I just want to give context because some of you are looking at me like, why is it
yes,
only
I'm
an hour?
sorry. Uh-huh.
No, you're good. You're good. I just wanted to give clarity on that. So I know I have multiple students in here that are taking next gen. So I do want to give that
Hmm.
caveat for you. Yes,
But
I think that is one of the frustrating parts, right? About
mhm.
the MPT in general, the PT, how whatever you want to call it. It's that when you go and you look at these sample answers, it's very clear that the person did not write it in 90 minutes or 60 minutes, depending on which version of the exam you're taking, right? One of the tools I do think is helpful, and obviously, Natalia, this doesn't really help you because with Next Gen, we don't have any sample, like we've talked about this, it's really hard to find sample PTs. And so, but one of my recommendations for those of you who are taking the MPT, so the UBE version, or even Natalia and Fabiani, if you're gonna do practice old MPTs, go look at the Texas Bar Examiner's website and go look at the um New York Bar Examiner's website because they both have old answers that are actually written by students, people who were sitting for the exam, and it shows you what they wrote. And while I understand that Barbary, yes, California is also 90 minutes. I do think it's really helpful though for people to be able to see sample answers, right? California also has sample answers on their website of both essays and MPT answers that real students have written in the time conditions. And I think, in my opinion, that is a super, super helpful place to look. Yes, New Jersey also has it. I think a lot of the websites do. I know Illinois does not. But at the end of the day, if you're taking UBE, you're all given the same essays anyway. So you can go look at a bunch of sample answers and see what other students are writing versus what Barbary or Themis's dream answer is that someone probably wrote over the course of 4 hours. Sanjana, do you have a question?
Yeah, I think one thing that I just struggle with is in the beginning, if I don't spend proper time reading what's happening, like if I skim, it's a
Yep.
waste of my time because I really am not able to place what do I have to pick from where and how much time do I need to spend on each document or just mentally allocating that, okay, it's 10 minutes for facts. And if you don't move on, you really spill over into the time for the next MPT.
No, 100%. And that is one of the challenges too. If you're in a state where you do get two MPTs and you get them, they're given to you at the exact same time, it can be really hard to time manage. So I'm going to try to address all of those things today. Realistically, this is probably gonna go a little bit long. I have to wrap us up by 11:30 Central, 12:30 Eastern, 9:30 Pacific. Sorry, my Pacific people, this is kind of early. But like I said, if you need to leave early, just leave and I will circulate out the video for this. Okay. Okay. So, one of my first things I would like to address with you all is how I code my MPT. Okay. So a lot of people struggle with the organization. They struggle with time management and they struggle to be able to look at all of the facts and information and adequately write things down. So one of my recommendations is that you come up with a key for yourself. What does that mean? You know, when you were growing up, how you would make like little maps in school and you would have like the arrows meant, mountains, and then the squiggly lines meant the ocean or whatever, right? That's what I essentially do with my MPT. Okay. My brain is very defense minded because I represent defendants in most situations at my job. Okay. That was the same thing with my summer position. And so when I see a triangle, I think of myself and my side. Okay. So for me, when I am reading something, once I recognize who I represent, anything that helps my argument, I put a triangle next to. Okay. Anything that helps the other side, I put the pi symbol next to. Okay. Now, this is not, you don't have to follow the exact same coding structure that I follow, right? I'm giving this as an example. But if this works for you, then by all means, please use it, right? Okay. So triangle means my side, pi sign means the opposing side, okay? The other thing that I do is if I find an element or a factor, right? I circle those things. So elements I circle because I know that that's something I'm going to want to address. I then put brackets, so like a literal bracket in a pen around information that I know I want to come back to that's important to support my argument or that is an important piece of law. I also put brackets around something if it says legislative intent. Okay. If you are reading a statute and the statute says the intent of this legislation is, you need to discuss that in your MPT. And oftentimes students overlook that. And then people ask me, well, why do I need to focus on that? Why do I need to bring that up? And the reason you need to bring that up is because oftentimes when legislatures give us the intent of something, it actually gives us a very clear idea of how then it should be enforced. Because we, as the judiciary, we being the grander judiciary, obviously not us as individuals, we are responsible for interpreting it, right? And applying it and figuring out what it means, right? But in order to interpret it, you need to know what the legislative intent is. And so if you have legislative intent as a description in a statute, that's very important, and we need to mention that. What are other things I do? If it's something that's like very important that I want to make sure I come back to or include, right? I'll put a star next to it. But oftentimes my main coding is triangle if it helps my side, pi sign if it helps the other side, brackets if it's something I want to make sure I quote or pull directly from, and then circles for elements. Does anyone have any questions on that? No? Great. Okay.
I have a question.
Yes.
Hi, Milana. When you say elements, what exactly are you referring to? I just want to make sure I
Yeah.
have that.
No, for sure. So let me pull up an example in this MPT. Hang on. I'm literally singing to myself. How embarrassing. Oh my God, I'm such a weirdo. You guys are like, who is this girl? Okay, let me find this. There's not honestly a great example in this one, if I am remembering correctly. Oh, here we go. Okay, so if you go to page 18, let me pull this up. Close your eyes so I don't get you guys dizzy. I would circle these.
Okay.
Like I would put circles around the 1, the 2, the 3, the 4, or like A, B, C, D, or like sometimes it's like a little I and then the 2 little I's and then the 3 little I's and like the IV, for like
Okay, perfect.
Roman numerals. Is that helpful?
Yeah, that's helpful. Thank you.
Okay, cool. So that's what I mean by elements is like when it's really clearly something where it's like, okay, there's 1, 2, 3, and 4, right? Because normally that's going to be something we talk about. And oftentimes, yes, oftentimes what I end up using for my headings are elements depending on the situation, right? So for this specific MPT, how many of you read it? Did most of you read it, I'm assuming? Maybe? Okay. I'll just quickly go through our task memo. Close your eyes, it's gonna make it easy again. Okay, so we pop up here. Our client, Barbara Worley. So I know that anything that supports Barbara is going to have a triangle next to it, okay? Our client, Barbara Worley, is renting a house. She's a little over halfway through a 1-year residential lease and has encountered several problems in the house. She would prefer not to move, and once the condition repaired, she needs to know her options under Franklin law to remedy each condition. In Franklin, specific statutes govern the landlord-tenant relationship. Both landlords and tenants have certain statutory duties in addition to any duties they have under a written lease. Please draft a memorandum analyzing and evaluating Miss Worley's options with regard to each of the unrepaired conditions which are described in the attached client letter summary. What does this tell me? Anyone? You can comment it too, or you can just, it's a memo, which means it's objective or subjective.
Objective.
Okay. So our goal then means that we're going to have to talk about pros and cons of various arguments, right? And you already want to do that if it is subjective, okay? That is something you want to do. But it's going to be couched differently. If my goal, let's say I'm writing a brief to the court in support of Miss Worley. When I add in a counter argument, it's going to say something to the effect of, the other side may argue X. However, in Miss Worley's defense, A, B, C, D. Does that make sense? Whereas here, right, we're going to want to have potentially separate subparagraphs that talk about these facts are in favor of our client. However, there are these facts in the law, and the interpretation of that law would likely result in the other side winning this argument. Okay, it's while we're incorporating counter arguments in both, they're framed differently and communicated in different words. Okay. If more than one option is available with regard to a specific condition, explain the potential advantages and disadvantages. Okay, so I already thought to myself. I already thought about the fact that I'm going to have to do that for these, okay? If an option is not available with respect to a particular condition, briefly explain why. Do not include a separate statement of facts, but be sure to incorporate the relevant facts, analyze the applicable legal authorities, and explain how the facts are and law affect my analysis. Okay. Okay, so I'm looking at this and I already am seeing that this is a summary of the interview, which means they did not give us an example of how they want this written. That for me means that I have a lot of creative liberty, which kind of sucks because it means I'm going to have to decide how I want to organize it, which isn't always a good thing, right? So that is something that you always want to flag to yourself is okay, now that means I'm organizing it. Okay. I talked about this in my last MPT workshop, but I am a little bit all over the place as it pertains to how I read MPTs. Some people are very strong believers in one way or the other. You read the file and then the library, or you read the library and then the file. To me, it's going to depend on the context. If I am writing a brief, oftentimes I will read the library and then come back to the facts. Because the library will usually give me some context on how I want to structure my argument. And the library will then guide me as to what facts are important to have a stronger argument. Whereas with a memo, with something that's objective, I have less of an opinion one way or the other. And so honestly, and I say this a lot and you guys get annoyed with me, but it's kind of just going on vibes. For this particular one, I'm going to go ahead and read the facts first, read all of the stuff that we have in the file, because I think that it's going to give me some context as to what the hell's going on here. Okay. So we met with Miss Worley regarding her dispute with the landlord over the repairs needed for the rental house. Okay, in January, 3 bedroom, 2 bath. She's the only occupant. She has a dog. Pet addendum on the lease. Okay, so she's allowed to have the dog. That's good to know. Okay, she's not doing anything nefarious with the dog. The house has 8 rooms, yada, yada, yada. I don't really care about that right now. She's experiencing a number of problems. Okay. 2 months after she moved, the toilet in the bathroom began to leak. Okay. They keep talking about a number of problems. So I know that's not going to be the only thing, but I am going to jot that down, right? And I'm going to put a little triangle next to that because it's going to tell me, oh, that's a fact in my favor. It shows the toilet stopped working after 2 months. Okay. In late March, she began having problems with the outdoor sprinkler. Okay, once again, another triangle. That's the second problem we're seeing. In May, a smell in the guest bathroom or bedroom. Okay, I'm gonna kind of skim this. Okay, so basically it sounds like the carpet and the door are having issues. She discovered the gaps between the door and the door frame, tried to open the door, wouldn't budge, she placed a plastic bag. Okay, so she's trying to fix it. The carpet near the sliding door is increasingly discolored and smelly, and she has noticed mold growing. Okay. So as I'm also thinking about this, right? A leak in a bathroom on a scale of 1 to 10, how bad is that? Right? That's pretty bad because that can cause a lot of problems. Okay. Also, having a bathroom that's not functioning, bad. Yeah, like a 9, right? I would put that pretty high on the scale of 1 to 10. What about the sprinkler system? Like, okay, that's a nice luxury to have, right? That's something, but it's not necessary for the home to function. So that's pretty low on my scale. Okay. The carpet smelling and having mold, right? That can cause serious health issues. So on a scale of 1 to 10, like I would say that's probably higher on my scale, right? Okay, I'm gonna keep going. Whirly keeps Bentley in the laundry room on weekdays while she's at work. That's kind of sad for the dog. Because the doggy door allows her to, okay. A golden retriever. I have a golden retriever. His name is Cooper. For those of you who don't know, he's a year old. He's the love of my life. Okay. Whirly is out of work. Oh no, he chewed on things. Not good. 5 days ago, Whirly realized Bentley had, okay. Okay, so the dog has done damage. The difference, right, between this one that I'm already flagging in my brain compared to the other three is that this is something that she caused, right? It was her dog. But this is her problem. She's the one that messed this up. This is not the person who, this isn't the person's fault who owns the home, okay? Really notified Spears about the toilet sprinkler. Okay, she notified him. We're gonna go through the emails. She's considering to make arrangements. Okay, she's paid her rent on time. So she's thinking about having a handyman fix it. That's helpful. Yada, yada, yada. She does not want to leave the home. Okay, so this is the rental agreement. I'm looking through this. I'm looking through this. Nothing's seeming particularly important. I'm seeing here that no animals are allowed unless they have a pet addendum. And I remember talking about the pet addendum. Destruction of premises. Okay. If the premises becomes totally or partially destroyed during the term of this agreement, and it is seriously impaired may terminate the agreement immediately. Okay. And then you have the tenant general responsibilities to keep the property clean, to dispose of garbage, not to leave windows in an open position, promptly notify in writing of all maintenance. Yard maintenance. The tenant will water the yard at a reasonable and appropriate time to maintain the yard. Okay. So this gives us some context on some of the things we talked about, right? Now I'm questioning, did she leave the door ajar, causing the mildew in the second bedroom? Then I'm questioning, okay, she did notify him, which is good. I'm questioning though about the yard maintenance as it pertains to the sprinkler system, right? Because it says here it's her responsibility to keep the yard nice, not the responsibility of the landlord. Okay. So all of these things are the things that are popping up in my mind as I'm reading this. So I would probably put a pi sign next to not leave windows and doors open. It says allegedly we think she put it in writing because we mentioned an email earlier. So I would probably put a triangle next to this. I would put a pi sign next to this because that supports their argument. Okay. Next page. Okay. These are the emails. Every time you see a correspondence, I really want you to pay attention to the dates because this gives us a helpful timeline. One of the things I noticed with students for the MPTs is you guys do a really good job of being detailed about this type of stuff, of like what the actual content says. But sometimes we forget about things that are really important, like the date, right? When did they get contacted? Or who is sending the email to who? Are other people notified? What is the subject? Does it say urgent? Repair needed immediately? What is it communicating, right? Okay. Hi, Sean. Last weekend I noticed some water on the floor. Okay. Toilet leaking, come by. Okay. 8 days later, that's crazy. He says he'll be back. Okay. He'll be able to swing by Saturday morning. Okay. He didn't show up. Not good. Okay. She follows up then, I'm bad at math, some amount of time, 7 days later, and he hasn't. Okay. Shown up. We're seeing now that the toilet is getting more problematic. The automatic sprinkler system isn't working. Um, Okay, that doesn't really give us any other information. He doesn't respond for another 7 days, 6 days. Then once again, we're not hearing from him again. Okay, May 4th. Okay. He still hasn't stopped by. Okay, this looks like the last email. I've been very patient. The toilet in the bathroom has been leaking for the past 3 months and the automatic sprinkler system isn't working. The sliding glass door in the bathroom or in the bedroom is okay. This is now making it uninhabitable, right? She cannot use the guest bathroom. That's really important for us to know. It's taken a long time for us to get to the point where there's a massive concern, right? Obviously, the leaking toilet is bad. The sprinkler system is mid, we've decided, but we have a lot of concern about this growing mold and the inability to use one of the bedrooms, okay? Why should I pay for a 3 bedroom? So she has communicated this to him on May 26th. When was the first day she sent an email? February 19th. 3 months. Okay. Important to note. Okay, this looks like the quote for getting things fixed. We see here the amount. I don't need to look at this right now. I know I'm going to come back to it because I'm going to have to probably cite directly to this. Okay. Now we get to the library. I never read the statute first. I always go to the cases. People have hot takes about that, but that's just my personal preference. So I skip down to Burke v. Harris. Okay. Defendant Ashley Harris appeals judgment in favor of plaintiff. The issue in the appeal letter is whether misapplied the law when it found that conditions proved to exist were non-substantial and therefore not a breach of warranty of tenability. Okay. Sought possession of the at trial. The tenant testified that the roof and windows of the premises had leaked during her entire term of tenancy and caused water damage. Okay. Personal property. Was there anything about her having damage to personal property? Our client. No. So that's not super important for us, but I do think those are things you should be noticing. Those are comparisons. Do you always read the most recent case first? I always read whatever the first case is in the case file, like whatever it is. I don't pay that much attention to it, but that is a good question. You want to be automatically comparing and contrasting the facts of our client to the facts in these cases if you read the file first, because that will make it so you can incorporate those arguments or those perspectives into our argument. Does that make sense to everyone? So next to personal property, I might put a pi symbol here because this is a contrast compared to our facts, okay? Tenant also testified that the thermostat was broken and that the shower had leaked. I'd put a little defendant sign by this because the shower leaked similar to the toilet leaking. Tenant offered evidence several letters she had sent complaining about the roof and other conditions, as well as photographs documenting the problem. Landlord denied receiving any such letters, asserted that he had not been inside the premise. Okay, this is different than our situation. And why is that?
Isn't there an email thread between them?
There's an email thread, right? And there's a difference between mail and email, right? And so that's something that you should flag to yourself of like, okay, it's clear that our person did in fact receive at least some of the emails. Now, we don't know if we don't know technically, did he receive the last email? It's unclear because he didn't respond, right? But theoretically, we know he at least received some of the emails, which is important to us. So I would put a defendant symbol by this. Okay. Found the conditions were not substantial as defined by the civil code. Accordingly, it entered judgment for landlord in possession of the premises and past due rent. Okay. In Gordon v. Centralia Properties, the Franklin Supreme Court held that in every residential lease, there is an implied warranty of tenability. Okay. This is something I would bracket, and it would probably be from Gordon to tenability because that's something I want to include in our memo. Every property has an implied warranty of tenability. Okay. Held that a tenant who proves that the landlord has breached the warranty of tenability is entitled to not only maintain possession of the premises, but also to an appropriate reduction of rent corresponding to the value of the premise. The Gordon Court held that a tenant is not entitled to a reduction of rent for minor violations that do not materially affect the tenant's health and safety. I once again would probably bracket this, right? Because that seems really important. That's a key holding. That's a law that I think is going to be really impactful for us. It's codified in the Franklin Code. Under the statutory scheme, when a tenant raises a breach of warranty of tenability as a defense in an eviction case, the trial court is required to determine whether a substantial breach has occurred. If the court finds that there has been a substantial breach, it shall order that the landlord make repairs and correct conditions caused by the breach. Order that monthly rent be reduced by an appropriate amount and award the tenant such possession of the premises. Section 540 requires that the landlord of a building intended for human occupation put it into condition fit for such occupation and repair all subsequent conditions that render it untenable. Under 541, a dwelling is untenable for human occupancy if it lacks effective waterproofing, weather protection, plumbing, heating. Okay, this is another thing I'm putting brackets around, right? That's really important. That gives us exactly what constitutes a lack of tenability. Does that make sense to everyone? Okay. Here, the trial court found that the premises, whatever, were not properly waterproof from the outside elements. The thermostat did not work and the shower leaked. The trial court erred when it concluded that these conditions were non-substantial. The conditions are not merely cosmetic defects or matter of convenience, but affect the tenant's health and safety. Also bracketing this, and I'm putting a pi/triangle here because health and safety, some of our issues fall in that category, right? I'm talking about the leak in the bathroom, and I'm talking about the leak in the mold situation that we have going on in the second bedroom. The conditions for cosmetic matters or convenience, I'm kind of thinking to myself, okay, the watering of the grass kind of feels like a cosmetic issue. And the dog chewing up the board also feels like it falls into that category. Okay. Okay, entitled to judgment as breach of warranty, yada 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 yada. To determine the appropriate reduction in rent, a trial court may either one, measure difference between fair and substantial, or fair rental value of the premises if they had been as warranted, and the fair rental value as they were during occupancy in unsafe or unsanitary conditions, or reduce a tenant's rental obligation by the percentage corresponding to the relative reduction of use of the leased premises caused by the landlord's breach. Okay, what am I doing with those little numbers? I'm circling them. Good job. A plus. Are you okay, Sanjana? I just saw you hit your elbow. Oh my goodness. Okay. Additionally, the trial court must order landlord to make necessary repairs, yada, yada, yada. Okay. Does that make sense to everyone? Did you see how I read that? Was that helpful or did that just feel like gibberish? I'm seeing heads nodding, so that makes me feel better. Also, like elementary school me is absolutely floored at the fact that I'm reading all of this out loud to a group of like 40 people because I never could have done that in elementary school. Thank you so much for the feedback. That was super helpful. That's helpful
Yeah.
for me
Oh,
because sometimes I feel
sorry.
like I'm just talking into the abyss. Who's talking?
Ilana, I was going to say that's really helpful. I feel like I've been following the read the file first, like strictly approach, and this was really helpful because it's like actually seeing the facts before going into the cases makes it a lot easier to actually understand what's going on. And I think
Yeah.
that I easily get turned around if I don't have an anchor. So not only your tips for like bracketing, circling, putting symbols, but like reading what makes sense to read first, I think is really helpful.
Because I think one of the other things I've noticed is like a lot of you come to me and you're like, I get so bored reading the MPTs. And like I start to disassociate and like I'm not really paying attention. But do you see how like wrapped I am in what I'm doing? Like I'm enthralled by this problem we're solving, right? And like, do I give a shit about Barbara and her like weird issues with her rental agreement? Like, no, I don't care. I have no desire to do tenant law, right? But like, I read this as if my life depends on it. Like, this is the most interesting thing in the world. I like gaslight the shit out of myself, right? Because like, if you are this enthralled in the problem, it makes it so much easier to actually write the answer because I do not have to go back and reread shit. So sure, I might have to go back and like pull the elements so I can directly quote them, right? Or might have to go back and like make sure I have the citation correct. Or like, oh, I remember they talked about this one specific thing. Um, how do I do that? Right? But like I can tell you so much about these facts and like so much about what's happening that it's almost embarrassing. Does that make sense? And I know it's not fun. Like this is not probably how anyone wants to spend their Sunday morning. Um, but if you read it like this, like it is the most exciting piece of like Love Island drama. It's like a reality TV show, right? Like we're enthralled. We're enthralled. Okay, sorry. I'm like getting on a diatribe and you all are like, just tell me how to answer this. Okay. Um, I made it more engaging. I'm thrilled to hear that, Amber. How do you know which rules are going to be used and which ones aren't? We will get to that after I get off my like soapbox. Okay. Sanjana, yes.
Yeah, sorry. Will you be addressing like this is the Court of Appeal and the previous one was, I think, Supreme Court?
I'm
And
not probably going to talk about that if I'm being super honest with you.
does it matter?
That's the $1 million question.
Oh, that's also appeal. Sorry,
These
my
are
bad.
both Court of Appeals, so
But
no, it doesn't matter.
okay.
So here's okay. Yeah, that's a good question. I should have probably have talked about that at the beginning. These are important things to note, okay? Because occasionally what they'll do is like some crazy shit where they give you a Supreme Court case that's like overruling part of one of the other cases. That doesn't happen super often. It's something that I would love for you all to like observe. But it's not something that I feel like is oftentimes something they're testing. One thing you can say in certain circumstances, especially when you're writing a brief, is like if one's a court of, let's say like one's, I mean, they don't really do this very often, but let's say one's like a Supreme Court decision for a state, and then one's like a Court of Appeals decision, and the Court of Appeals decision comes subsequent to the Supreme Court decision and it's kind of in conflict, you would want to say that, right? Of like, this technically is like in conflict with this other law, and it's likely the Supreme Court will take this up. But like, I very rarely see that being something that they're like actually wanting you to address. Does that make sense? Like, very rarely is that what they're wanting you to focus on? So it might be something I would like observe, but it's not something that I would necessarily like anticipate being super important in the MPT. I also think realistically what they're trying to do with these MPTs, especially in the more recent years, is to see if you can like form a legal argument and like organize shit. They're not trying to test your ability to understand like conflicts of law.
Yeah. What I have noticed also, Ariana, and I'm sorry. So when like reviewing different PTs and reading case law and everything, I have noticed that when like a authority overrules another one, they usually mentions that in the analysis or the application of all the new rules.
Correct.
So they will tell you these decision overrules, case, whatever the analysis that the court apply for this case. And that you go forward with that. And I usually just like go I do what Ariana does, like go how it is in the MPT file. Like I just quickly look to see which is the Court of Appeal or just a lower court and see what's going on. But basically I just read it like that because I feel like if they put it first, there's a reason for it's there.
Yeah.
So
100%.
that's what I do. I just read the case law pretty quickly in that
Yeah.
order.
Yeah. And that's something that I think like a lot of people will adapt with time. Of like what works for them and like how they want to read stuff. Hey, Matthew, yeah, Amber is correct. So once again, I'm telling you all how I do symbols. I recognize there is confusion sometimes with the defendant plaintiff because oftentimes a triangle means defendant, plaintiff is P. Technically here we would be the plaintiff, right? When it comes to this specific MPT. For my brain, it's easy for me to just do triangle means my side because that's how I do it in real life. That's how like all of my internships have been. I work for a defense firm. Like, does that make sense? And so that's why I do it that way because otherwise to me it's confusing. When I go back and look at my notes of like, oh shit, that says pi, but that's my side. Like that's just my personal preference. I for sure 100% support you guys doing whatever you want. Some students do like circles and squares. Some people do stars and hearts. Some people do whatever, right? This is just an example of how I do it. Um, okay. Next case. After suffering through two separate bed bug infestations, perfect. Jordan moved out, filed a complaint, yada yada yada, seeking that they want rent and out-of-pocket expenses related to the infestation. After a bench trial, the trial court found Willowbrook responsible for the first infestation, but not the second. It awarded Shea a fraction of the damages he sought, limiting his recovery of his out-of-pocket and declining any reward of rent. The facts are as follows. Within days of entering into a 6-month lease at Willowbrook, Shay began to suffer from insect bites, which were discovered to be bed bugs. Okay. Within days, right? That's important for us to flag. That was pretty immediate. From there, he reported this to Willowbrook, which sprayed his apartment, replaced his carpeting, and cleaned his apartment thoroughly to remove the bugs. While this work was being done, Shay stayed at a nearby hotel for several months. Okay, so staying at a nearby hotel implies to me damages, right? He spent his own money to do that. That's different than us, right? Because there's no indication that she's moved out, that she's needed to move out, that she's not able to use the home, right? There are portions of the home she's not able to use, but the home itself is habitable, okay? For several months after Willowbrook cleaned the apartment, there were no bed bugs. Okay. In January 2021, so 6 months later, he renewed his lease for an additional year, then departed to study abroad for 3 weeks. Upon his return, he started to get bed bug bites again. Okay. Why do you think they included the fact of the 3-week trip to study abroad? Right? They're trying to imply that he probably brought the bed bugs back from Europe or wherever the hell he was. Does that make sense? Yeah, assuming he got them somewhere else. So that is an important fact for us to know. Okay. He finally moved out October 2011, 11 months before 2 months before his lease ended. Okay. So then I'm going to go back and do math. January 2011. Okay. 3 weeks. Okay. Great. Then, okay, so that would have put us right still in January. So he still stayed there for 9 more months afterwards. That's interesting for us to know. Okay. The trial court denied Shay's claim that he was entitled to a full refund of all the rent he had paid over the course of his tenancy. When a landlord breaches the warranty of tenability and creates an untenable property there, as alleged, there are several options. What are we doing with the numbers? Circling them. Good job, everyone. So honestly, I'm not even going to really read this right now because I'm going to have to come back and copy and paste it anyway. So here we go. In his lawsuit, Shea sought to recover all the rent he had paid, $16,000. That's a lot of rent, pursuant to the initial and renewed release. Okay. We believe the trial court correctly declined the award of the rent. Okay, that's helpful. That's good to know. That's not going to probably help our side, right? So once again, you pick your symbols. I'm going to put a pi sign because that helps the other side. But for some of you, you can do whatever symbols you want. First, the evidence supports the conclusion that Willowbrook's efforts to address the first infestation were successful. Shea even renewed his lease for another 12 months. Okay, so the court is considering whether or not he wanted to stay there, right? Theoretically, if this was so bad, why would he sign another lease? That's helpful for us to know. Thus, there is no factual basis to support him getting damages for rent in the 2010 under the lease. Nor is there any basis for award after the second infestation from when he came abroad. He failed to demonstrate that the 2011 prolonged bedbug infestation occurred through Willowbrook's fault. Okay, so this is also something that we're going to want to flag, right? I would probably put brackets around. I would probably star or underline this actually because this isn't necessarily a piece of law we want to include, but this is a fact comparison, right? We need to consider whether any of these individual issues our person is struggling with are innately tied to the owner. Does that make sense? Okay, everyone's shaking their head. That's super helpful. If Shea were responsible, he would have been obligated to resolve the issue himself. Great. If Shea believed that his landlord was responsible for the bug infestation, he had an obligation to mitigate his damages by promptly notifying and giving him an opportunity to resolve the problem. So that's also going to be something. This is something that I think this is something that's really helpful for us, right? Because he needed to mitigate his damages by promptly notifying. Our person promptly notified the landlord, right? So this is something that I would put a triangle next to. Since this did not occur, the trial court declined to find Willowbrook responsible for the second infestation and concluded that Shea was not entitled to vacate the premises under 542A3. Because Shea retained possession of the apartment and reaped the benefit of staying, he could have held that responsible for the remaining 2 months of rent, yada, 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 yada. The trial court correctly declined. Shea requested $2,000 for motel and medication costs he incurred. However, Shea submitted receipt for only a $400 motel room. Okay, so what we're seeing here is that a receipt is very important. So if our person does go ahead and have the handyman fix stuff, we want to make sure she has a receipt to prove those damages, okay? And that's really all we got, okay? That's all the stuff that they've given us. Based off of this, how would you organize your MPT answer? Anyone? You can also comment, you don't have to speak.
What do you mean by the issue of the issues that the tenant is having? Like the room with the mold, the issue with the toilet, thinking like there's different issues, right?
Yep. Anyone else have any other ideas? The elements from the headings of the second case. Okay. Per issue, okay. Let me go back to the second case quick. Pull up those elements. Oh, sorry, I skipped ahead. Okay. Repair and deduct the costs. Repair and sue if the cost of the repairs exceeds 1 month's rent. Vacate the premises and be discharged of paying rent further. Withhold some or all of the rent if the landlord does not make the repairs. Okay. Technically, you can do either. You can do either. So that's super great. We figured out both options. Personally, to my brain, it's going to make way more sense for me to go per issue in the house, right? So I personally would have chosen to organize it by thing in the house. But something in my brain is flagging for me. There was something in the memo from our boss, right, that said something about talking about the different types of damages that like are the different types of repairs or something like that, right? I'm remembering that and I don't remember exactly what it said. So let me come back up to my memo. And I do this normally before I start writing anything is I come back to the assignment, the task memo, because usually there's some specific instruction that I want to make sure I follow and I want to make sure I don't forget anything. I'm not really probably going to read the beginning because I know what's going on. Please draft a memo to analyzing and evaluating Ms. Worley's options with regard to each unrepaired condition, which are described in the client interview. If more than one option is available with regard to a specific condition, explain the potential advantages and disadvantages. If an option is not available with respect to a particular condition, briefly explain why. Which means to me, if I'm going to organize it by issue, whoops, this is how I'm going to organize it. And then we have the chewed floorboard. Okay. So because this is saying to me that I basically need to talk about all of the options for all 4 of these, what I'm going to do so I can remember is I'm going to list out quickly all 4 of the elements listed in that case, Shea v. Willowbrook properties. So I'm going to go like this underneath. I want to repair and deduct the cost of repairs. Jeez. Okay. Oh my goodness. Repair and sue if the cost exceeds.
And these are elements from case number 2?
Yes, it's on page 18 of the packet, if that's helpful. And then
Thank
number
you.
4, I'm going to withhold some or all of the rent if the landlord does not make the repairs provided the conditions. Okay. Does this make sense to everyone how I'm doing this? And then basically what I'm going to do is I'm just going to copy and paste this underneath each one. Oh, geez. I hate Google Docs, but this is easy. There we go. She's a solution-oriented queen. Okay. Wow. That was riveting. How much fun are we all having? I'm having so much fun. Okay. After I see that and I put those down, right? When I'm looking at this Shea v. Willowbrook Properties LP, I see that they're actually citing to the Franklin Civil Code, and that's where they pulled those elements from. So now, before I continue writing anything, I'm going to go back to the code and I'm going to read it quick. So I'm going back to page 13, which I'll pull up here. I should have asked, can you guys see my screen? Oh my God, I just had this idea that I have just been absolutely babbling on and no one could see my screen. I just had this like moment of like, oh my fuck, what am I doing? Okay, I'm thrilled. If you ever are on here and I'm talking like a crazy woman, please tell me if you can't see my screen because that would have been so embarrassing. Okay. Okay. Anywho, we're going back to the code. Okay, so the lesser requirement of tenability, the lesser of a building intended for human occupants must put in condition fit for such occupation and repair all subsequent conditions that render it untenable. A dwelling shall be deemed untenable. Flag, warning, that's important for us, okay? Effective waterproofing, plumbing, or gas. Okay, so what am I going to put next to this effective waterproofing? I'm going to put a defendant symbol. Once again, my preference, you do what you want. Same thing with plumbing, right? Because we don't have the plumbing's not working in the bathroom. So we got to put that. Heating, electrical, floors must maintain good repair. Maybe that one might, but like at the same time, we know that the reason the floor is fucked up is because of our dog. So like, okay, if the landlord neglects to repair a condition that renders the premises untenable within a reasonable time, okay, It says a reasonable time. It's not giving me a specific amount of time, and that's also important for us to remember. Okay, these are the 4 things we're talking about over on this side. Okay, so that's, we don't need to really. Moldy carpet is floor in disrepair. Yes, it is, but I theoretically was focused on this with the moldy carpet of like the ceiling not working, but yes, technically you could talk about both. If the exercise of any of these remedies leads to an eviction action, a justified use of the remedies provided yada 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 is an affirmative defense and may shape the tenant's relief. For the purposes of this section, if the tenant repairs, oh, here we go, makes repairs more than 30 days after giving notice, the tenant is presumed to have acted after reasonable time. Okay, so that's good for us. I'm going to put the little brackets around it. I'm going to put a little defendant symbol. We move on. Yada, yada, yada. No duty on the part of landlord to repair shall arise if the tenant is in violation of any of the affirmative obligations to keep the premises clean and sanitary, to properly use and operate, not to permit any person or animal on the premises to destroy okay, so this does not help us. So you're going to put the other person's symbol next to this. I'm going to put a pi sign, right? That does not help us because our dog is the one that tore everything up. Sorry, my phone is like vibrating and it's annoying me. Does that make sense? Then we're going to come down here, eviction proceedings in an eviction action involving residential premises, yada, 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 yada. If the court finds a substantial breach, 1, 2, 3, okay. If the court determines there has been no substantial breach, then the judgment shall be entered in favor of the landlord as used in substantial breach. Okay, once again, putting a bracket around this. I'm pretty sure we maybe did that in one of the cases, but this is still helpful for us. Okay. That was a lot of information. That was a lot of information. So let me think for a second. What would you say the issue statement is for the leaking toilet? Anyone? The issue is whether, someone put it in the chat. Whether or not the issue with the toilet makes it untenable. The issue is whether the landlord breaches duty by failing to repair the leaking toilet. Both of those are perfectly wonderful and fabulous. So yes, what I would probably put is the issue is whether the leaking of the toilet makes the home untenable. Then I'm going to put the rule, analysis, and then I'm going to put the conclusion. Okay. Under the rule for the leaking toilet, okay, one of the things I'm definitely going to include is that the plumbing must be in good working order, okay? How I don't follow like black, or I don't follow blue book citations. I almost said black letter law. That's not sure I do follow black letter law, but I don't follow the blue book when it comes to citations because I'm terrible at blue book citations and because at the end of the day they don't really give a shit on the bar exam. So I would probably just literally put like Franklin Civil Code section. People ask me all the time, do they have the like symbol for the section symbol on the bar exam? I think there's a way to insert it. I didn't take the time to figure it out. So I just type section instead of doing the little like section symbol.
On Mac, it's option 6. I don't know if it lets you do it in the program, but
Yeah, I don't know if it lets you do it in the program. Okay. Hale is saying yes, ExamSoft does allow that. Once again, I just type section because personally I find it to be easier, but like you do what you want. Okay. Great. Okay. Then I'm gonna go back because I'm pretty sure one of these cases talked about. Where is Burke? Here it is. I should have actually marked up this document so you guys could go back and see where I did that, but I didn't do that, which was dumb of me. That's fine. Okay, here we go. Sorry, I'm like sitting here blanking. Okay, great. I also would probably then compare our situation with the toilet to the issue in this case as it pertains to the shower. The thermostat was broken and the shower leaked. Okay, so I would probably also say, a leaking partially, I would probably say like a leaking and somewhat inoperable toilet would be considered a toilet that's not working well. This, compares to the facts found in Burke, where the court determined that a thermostat not working as well as a leaking shower constituted a substantial breach of warranty. Does that make sense to everyone? Great. Okay.
Sorry, I had a
Yes.
question. That was a part of the rule or part of the analysis?
Super good question. I would put that as part of the analysis.
Mhm.
Sorry, I jumped and I didn't communicate that. The other aspect of what I would probably do for the rules section, specifically with this particular one, is I probably would say that I would probably say like Franklin courts have held that things such as not having a functioning shower constitute a breach of untenability. Like I would give that as an example, I'd put that in the rule and then I would compare it the way that I said earlier in the analysis section. Sorry, I didn't make that clear. That, etc. Then ultimately what I would do is I would compare and contrast the facts of Burke to our facts, right? And I would show how like the plumbing situation in our situation is a problem. Would you also take the time to write out the background of the case or just briefly? I would briefly compare them. I don't normally take a lot of time to synthesize the facts of a case because usually that's not going to benefit me a ton. Now, there are certain, like, once again, there are exceptions to everything as it pertains to this specific chaos of the MPT. There are certainly examples where, like, the case is exactly the same. Like, it is basically identical, right? And in that situation, I would potentially take time to take a, make a, what do they call that? A case like in legal writing. An illustration, a rule proof. Yes, good work, everyone. Yes, that was just a question. That was a quiz. But no, yeah, I would basically make a case illustration as it pertains to those cases if they're identical or if they're not at all the same. Right. But ultimately, what I normally do is I basically will say, like, in our case, this contrasts with the case of Burke because generally is the formatting I'll do for that. And then from here, once I've done the analysis section, I will then go into this conclusion, basically saying like what I think the actual damages are. And ultimately, I would say that she should have the handyman fix the toilet because it's been more than 30 days. And then she should just deduct the $200 that the handyman would charge, which you're like, where did she pull the $200 from? I pulled it from up here. Just deduct that $200 from her rent, right? And I would just say, like, essentially that the repair does not exceed 1 month's rent. Vacating the premises is unnecessary because she still has a functioning toilet. And then basically I would just say that like she can have someone repair it and it's not that big of a deal. Does that make sense? Cool. I think that's where I really should probably just do another workshop where I like put everything together. Alana, that's a really good question, but normally people have a harder time with this part of it. And so that's normally all I cover in the workshops. Because generally, I think the thing that people struggle with is like pulling the information, but if you want me to do one where like I actually put the things together, I can do a workshop about that. We would probably just do like a continuation of this one. Then, because theoretically we've all read it and we know what's going on. I did my other workshop on Little Tots, which is an MPT that is persuasive. So I could also potentially do that. A continuation would be super helpful. Okay, perfect. Okay, so we'll do that. I'll message you all. I'll record it. So if you can't come, then we'll just go from there. How I just did this is exactly how I write my MPTs live. Like I don't outline while I'm going. My outline is essentially my diagramming. Some of you I think are asking if I put like A or like B or like A or I think is what you're asking in the chat. I do that when it is a brief. I don't always do that when it's a memo, but you can. Yes, you can have this main outline. I'll figure out how to send this to you. How do we incorporate the cases in cases? Liv, can you pop on and explain what you're asking? I'll let Sanjana ask her question first. Go ahead.
Oh,
Oh, sorry, Liv. Go ahead.
oh, sorry. Can you hear me?
Yes.
I'm just wondering because like they talk about when you're doing like you're explaining whatever and you're connecting back to the cases with the rules and such. How do I take like because they want you to reference the cases within the cases?
Yep.
How do you
Okay.
kind of formulate that?
So like you're talking about the case like within Shay.
Yes.
Okay, got it. Sorry. I don't know why that was. So for example, in Gordon, okay, usually this is a general rule, everyone. I don't talk about the facts of cases within fact cases. There are exceptions to that. Once again, this is very much so generally speaking. So like I wouldn't go into the nuances of like the Gordon situation. What I probably would say is like there's a few options. One option is you can say in Gordon, the court held that a tenant who proves that the landlord has breached the warranty of tenability is entitled to not only maintain possession of the premises, but also to an appropriate reduction of rent corresponding to the reduced value of the premises. Or what I would say is Burke discussed the holding in Gordon, which found, or you can like quote directly and then say at the end. So let me show you this because I feel like what I'm saying is not making a ton of sense. What I would potentially do is I would say, in every residential lease, there is an implied warranty of tenant. Guys, I cannot believe I still have this cough. For example, and I would cite Burke v. Harris. You gotta italicize this stuff because it makes it so much easier for the reader. Okay, italicize, then you're gonna unitalicize. Citing, then you're gonna go Gordon. Liv, does that answer your question?
Yeah. So with that, so I'm putting that into my analysis section, right? When I'm comparing and contrast within the analysis,
This is a rule statement.
or into so it would go into
So
the
this
rule.
would go in a rule. But let me go like this.
Oh, okay. Okay.
But
That makes
the Gordon decision codified, yada 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 yada. Let me go to this one. I think there was one that it talked about the other case, maybe. No, I didn't. Of course I didn't. That's too freaking easy. Okay, hang on. Okay. In the Gordon case, held that the tenant who proves a landlord has breached the warranty of tenability is entitled not only to maintain possession of the premises, but also to an appropriate reduction in rent corresponding to the reduced value of the premises. Gordon Court further held that a tenant is not entitled to a reduction in rent for minor violations that are not materially. So I would probably still put this in a rules section. Like I'm still going to put this in a rules section. But there are situations where they do cite to cases within a case, and the cases they cite to within the case oftentimes, those they might give you the facts. And if they do give you the facts and you do want to compare it, that would be something to pull. So for example, I could totally see one of these cases mentioning someone's cat eating a screen or something, right? And they might be citing to a case talking about that. So I would say, like, for example, the court in Burke referenced the case of Gordon v. Centralia Properties, which demonstrated that the cat chewed through the thing. This compares to our case in that the dog chewed through the wall. So that would be an example of how I would incorporate cases within cases. Okay, Sanjana, your question, my queen. I'm so sorry.
No, sorry. I don't know if you've covered this in previous MPT workshops, but what sometimes I don't get right is like when is it persuasive or like just the formatting, how much does it really matter? Like this is an objective memo. What do we need to know when it's an objective memo, when it's a brief, like something that we don't have to think about, and how the tonality of everything sort of in the subject matter
Yeah.
changes.
So with objective memos, I normally format them either by, like, if there's like, this is a good example of like, oh, there's a bunch of issues, let me format it by issues. Or let me format it by these repairs, right? So what is going to repair and reduce the cost? What is going to be repair and sue? What's going to be vacate the premises? And what's going to be withhold rent? In persuasive memorandi, whatever. Um, or if it's a brief, which it would be if it's persuasive, honestly. Usually they tell you there's like an example. It says like this is how we format briefs at our firm. And it's like you have to basically put a conclusory statement at the beginning as your heading. So your heading is like a full sentence and it says like the doctor was negligent because he left a sponge in the patient. It's basically you're doing CREAC instead of IRAC. Whereas I personally am of the mindset, and you probably have all heard me say this 1,000 times at this point, I hate CREAC as a general premises because I don't want the first thing the grader sees is you being wrong. And I love you all. I love you all deeply. You're very smart and capable and intelligent. But odds are you're going to probably get a conclusion wrong at some point during the bar exam. And if the first thing the reader reads is you being wrong about a specific essay, you're priming them to assume everything else you're about to say is wrong. But if you're writing a persuasive brief, you have to put your conclusion first. That's how we write briefs. That's how the legal world works, right? So that would be an example of how like you have to look at the sample they're giving you for the formatting. And a lot of the time, this is not every time, most of the time for persuasive, they will give you an example or a template or a format they want you to follow. There's still the question of organization as to topic, but you have to follow that when they do that. Does that answer your question? Yeah? Okay, cool. Okay. What other questions? We have about 10 minutes before I have to hop to my next call.
I have a question.
Right.
And it comes to what I always ask you about the rules
Yeah.
statements. So in this case that we have like a lot of issues and we have to do the, RAC, issue rule analysis conclusion. So
Yeah.
like if I have a case law of, let's say, the Franklin Civil Code section, the same section, each of the issues, do I need to repeat myself and just put over there in the rules section my same case, my
For
same
this,
section?
yeah, no, I understand what you're saying. Well, so one of the things with this, right, is that you don't need to repeat the rules normally, right? You can say, as discussed above, there are 4 elements. However, within this specific issue of the broken automatic sprinkler system, this applies, right? But there's not going to be a lot of redundancy in this one, right? Because the
Mhm.
leaking toilet impacts tenability, right? That's the conclusion we're probably going to come to. This broken automatic sprinkler system doesn't. This is a cosmetic thing. We're going to pull that rule about the cosmetic aspect. Etc. Does that make sense?
Yes.
This one,
Yes.
then the guest room sliding door, there probably won't be redundancy because Maybe there might be some overlap between A and C because they both impact like tenability is probably what we're going to come to. But at the same time, there's a question as to whether or not she closed the sliding door and whether or not that impacted it. So this
Yeah.
was probably going to have the longest rule and analysis because it has the most nuance. Then we got the chew floored board. She's not going to get that. That's on her. That's on her puppy Bentley, which is such a cute
Yeah.
name for a dog, by the way, everyone. So if anyone has a dog named Bentley,
Yeah.
it's very cute.
Okay. Yeah, because I don't want to sound repetitive or, waste time in things that I don't need to do,
If you
especially in
see
the
that
next
you Yeah, if you find that you're being repetitive, and this is true for essays or MPTs, odds are you've incorrectly issue spotted.
Okay.
And when I say repetitive, I don't mean like the fact that we're going to reference back to this code 541 15,000 times in this one because like that's important. That's a huge part of this analysis. I'm saying if you are basically copying and pasting your rule section amongst multiple issues, you're probably issue spotting incorrectly or missing a nuance.
Okay.
That is a generalized statement. Once again, basically everything I say there are exceptions to, but that is a general rule of thumb. It should cause pause and make you take a step back. Will there be a main issue statement and rule in this memo before we jump into the main problems? So I would probably have like a to from, how is this formatted actually? Normally with memos, I copy the format of the brief, not the brief, I'm sorry, of this thing, the assignment memo or whatever the fuck it's called. So I would put like to from date re. You never say your name. You don't put your name. Don't put your name. Don't put your name. Say examinee. Don't put your name. I'm going to repeat that 1,000 times. Say examinee. Do not put your name. That can cause so many problems on the back end for grading and can cause delayed results. Don't put your name. Okay. So that's why when it says examinee, we're putting examinee. Okay. Then you could say, below is the analysis of Ms. Worley's issue as it pertains to her toilet, broken automatic sprinkler system, guest room, sliding door, and please read as follows or something to that effect. Yes, Samantha. Samantha, what do you prefer?
Samantha.
Okay.
So I have I have two questions. So I think this was very helpful, but I think one of the things for me is that I'm always running out of time, and I'm realizing that you're kind of doing your brainstorming on paper, whereas I think that I am actually annotating like by hand and like and I think that I'm reading things that I'm just taking too long to get through the files. So my biggest issue is just running out of time to the point where I feel like the finished product is like has more brevity than it should. Like I've touched on everything, I think, and but I think that there's like, I've been told like, oh, you need to be at like, 11 to 1300 words, whatever. And sometimes, we're barely touching 1,000. And so I'm realizing that time has been a huge issue. And then also, I think there's another issue with certain formats. There was a specific one that I did last week called Miller v. Trapp.
Oh,
And
yeah, sucks.
and I was like, what? It just, yeah, that one killed me. And then I know that there are, there's been a lot of predictions about, wild cards in terms of like demand letters, opinion letter of some sort, or like a closing argument. And I'm just wondering if at some point we're able to talk about those and maybe see like what a sample of those, like from a student perspective, actually looks like.
Okay. Yes. Yeah,
Okay.
yeah. We can do whatever you guys
I've
want.
overwhelmed you, I feel like.
No, no, no. You guys don't overwhelm me. I just love you all so much. Let me pause this recording, actually.